The court will call the matters of the state of Michigan versus Lawrence Buckner, case number 25S-00103, as well as 25S-00102.
Tiffany Woods for the people.
Good morning, Mayor. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Buckner.
Thank you, Your Honor. Assistant Public Defender Davy Lebo for Mr. Buckner in the 25S-102 matter.
Thank you, Mr. Lawrence Buckner. Can you please state your name? Good morning, Mr. Buckner.
Can you hear me?
I can.
All right. Good morning, Judge Washington. For the record, my name is Lawrence of the family of Buckner.
Thank you. Good morning, Mr. Buckner.
Grand Rising.
All right. We're hearing two pre-trials today.
Yes, sir. The 102 matter, I'd like to request an adjournment in order to review the discovery and some case law.
No, I think we're going forward with everything.
Mr. Johnson, what is your request?
Your Honor, I was appointed to this matter late Friday, but I've heard the wishes of my client. I likewise do not have discovery, but if he wants to proceed going forward, I asked the court set this matter for a final pretrial and a trial date.
So just so you know, Counselor Johnson, is once this gets set for the final settlement conference, which would mean it's going to trial, there is no plea offer. Negotiations are done. So I just want to make sure that you're aware of that if you're setting that for the final settlement conference.
Mr. Buckner, are you okay with that?
Yeah, and I also want to. I'm well aware of. I'm glad you said that. That if he go ahead and go forward, that there will be no plea offer, and at this point, I'm going to maintain my innocence as the black God I am, the divine being. So whatever the cause be, I'm going to accept all the consequences, standing 10 toes down. I'm tired of being discriminated against because of my color. Maybe if you would have read the police report correctly, I'm the victim. This is a travesty of justice. I've never seen somebody come to somebody's home and try to run them over with a vehicle and then they go to jail. Yeah, so I'm ready to go to trial. I'm really ready to go to trial. Because what? White people can just come to black people's house and try to run them over? And then, yeah, so yeah, I got a lot of anger.
Mr. Buckner, just because of this. Relax for me, Mr. Buckner. Relax for me, okay?
Black lives matter.
We're gonna handle this in the appropriate form. That's not today.
See right here. See nobody called me. See nobody called me. See I'm gonna tell you something, man.
All right. Mr. Lebo, what is it your plan to do with your case? He does not want to have an adjournment in this.
Your Honor, certainly I would do whatever Mr. Buckner is requesting. I am not 100% sure what Mr. Buckner is requesting at this point.
He wants to move forward with his trial rights, is what he has said.
My understanding is Mr. Buckner doesn't understand that he'd be giving up any potential plea offers in this case, so we would be moving forward to final settlement.
Clear. He's made that very clear.
And Judge, just to be certain, so on 102, that's Lebo's case, is that correct?
Yes.
And you've already gotten discovery, so I just need to send discovery to Counselor Johnson. Okay.
Yes, thank you.
Final settlement in both of these matters, April 25th, 2025 at 9:30 a.m. with jury selection being on May 2nd, 2025 at 8:30 a.m. Bond will continue in both cases.
Your Honor, is the April 25th date via Zoom?
Yes, April 25th is via Zoom, and jury selection on May 2nd is in person.
Thank you. And Your Honor, may I please have a breakout room, Mr. Buckner, and co-counsel if he wishes to join?
That would certainly be fine with me, Your Honor.
Yes, of course. We'll call the case of Ypsilanti Township versus Deshauna Perham, case number 24T00286.
Paul Barnett on behalf of the township.
Assistant Public Defender Davy Lebo on behalf of Ms. Perham. Ms. Perham, could you state your name, ma'am?
Deshauna Perham.
Thank you. All right, we're here today on pretrial as well as a bond violation. Apparently, Ms. Perham didn't go to community corrections after she was released from the Washington County Jail as ordered. So I scheduled her for a $20,000 cash and surety bond. That bond was continued by the magistrate upon arraignment.
Yes, Your Honor, I believe Ms. Perham is prepared to admit to that. Ms. Perham, is that correct?
Yeah. Yes.
Thank you. All right, ma'am, you have a right to have a hearing as to whether or not you violate the terms and conditions of your bond. If you are going to admit to that, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. All right, ma'am. Is it true that you were ordered to go to community corrections by the magistrate?
What is that?
One moment. You were ordered to go to the community corrections by the magistrate on August 9th of 2024. At that time, you were saying you lived in Kentucky, and they were going to set up for you to have the testing closer to your home, but you failed to go to before the magistrate, and then on September 30th, you were finally violated for failing to appear. You had I had also scheduled for you to come in person on October 2nd before me, and you didn't do that either. So the bench warrant was issued for you failing to appear in person. Is that correct, ma'am?
Yeah.
All right. I find that there's a knowing and willing admission to the bond violation. Are you satisfied, Ms. Woods?
It's actually my case, Your Honor, and yes, thank you.
Barnett.
Defense is likewise satisfied, Your Honor.
Where are we, please? On the pretrial.
Secretary of the Preacher would like to set this for final settlement conference. Friends, Ms. Perham would like me to address bond.
Final settlement conference in this case will be on April 25th, 2025 at 9:30 a.m. And jury selection will be on May 2nd, 2025 at 8:30 a.m. I'm pretty sure it was the person who told me that she lived in another state and we could come find her when she was here on September 18th of 2024. So what would you like to say about bond?
Your Honor, I would simply note that Ms. Perham is quite young. She's 20 years old. She does tell me she has a place to stay in Michigan and would stay in Michigan if released on bond and would have no objection to a tether.
Mr. Barnett?
Well, Your Honor, it's hard to do anything without her being here. She failed to comply with court orders. She failed to appear. I do recall her saying that on the record as well. So I would ask for at least a cash component of bond to ensure her appearance, and certainly a referral for a GPS tether.
So dumb, bro.
I'm sorry, what did you say, ma'am? Mr. Lebo, your client I wrote myself a reminder, one of the most rude people that ever came. I don't think she has any intention of following any of the rules. How did she get picked up?
Your Honor, I am not aware of that.
Okay. I see counsel in a breakout room.
Yep. Okay. Go! Will you hand me my screen box?
Now go. All right. I had a breakout room with counsel in this particular matter. Given the nature of Ms. Perham's demeanor at both the last hearing as well as this hearing, I am not going to reduce the bond at this time. What I am willing to do is to consider bond again on March 31st. So I'm gonna give her the court date she does have, and then I'll also give a court date of March 31st, 2025 at 9 a.m. where at that point in time, we can address bond again and take into consideration whether or not the prosecutor is able to proceed. Bond is continued at 20,000, 10%.
Thank you.
You're all set, Ms. Parham?
So what do I'm supposed to do, bro? Supposed to sit in here? Until when? When am I supposed to, when I'm supposed to sit in here till when? That shit don't make no sense, bro. It don't make no sense.
Just one moment. If you keep cursing, you're going to get contempt of court, and then there'll be added time. So you should stop. Mr. Pre, you can have them come, I'm sorry, Ms. Priam, you can have them come and get you. All right, the court will call the cases of Ozell, I think it's pronounced Hyman. Case numbers 25 FB 1007, 25 FB 1036.
Tiffany Woods for the people.
Muckler, Assistant Public Defender, here on behalf of Ozell Hyman. Mr. Hyman, could you have the jail unmute and then state your name for the record, please?
Hi, my name is Ozell Hyman.
Thank you. We have three trials in these matters today.
Yes, Your Honor. And we are able to move forward on both. Ms. Woods, I'm sorry, just now sent you an email about one of the cases, but Your Honor, our request today would be well, I'll start, Your Honor, should I start with the matter we're setting for final settlement or the matter that will be entering a plea on?
I don't think it matters much.
Okay. Your Honor, on the matter ending in 1007, on that matter, we would be requesting to set this for final settlement conference.
The defendant is aware that once it gets set for final settlement conference, there will be no further negotiations on this case.
Yes, Ms. Woods, he's aware. Mr. Hyman, you're aware of that. There will be no offers and you're not interested in pursuing any offers on this matter.
Yes, I'm aware.
Final settlement conference will be April 25th, 2025 at 9:30 a.m. Jury selection will be on May 2nd, 2025 at 8:30 a.m. Apparently you had a bond violation, a conditional violation on this case, and his bond was revoked by Judge Simpson.
That's correct, Your Honor.
As to the other case?
Your Honor, on the matter ending in 1036, we'd like to accept the offer from Ms. Woods, which I believe is to plead to the count of operating while intoxicated, and then a dismissal of the second charge, the open intoxication.
That is correct, Judge.
Or open container, sorry.
So he's going to plead to count 2, which is operating while intoxicated, and count 3 is going to be dismissed.
Correct.
All right, sir. It's my understanding you're going to be pleading guilty to operating while intoxicated. That will be a misdemeanor carrying a maximum penalty of up to 93 days and or $500 fine. In exchange for that plea, count 3, the open intox in a motor vehicle will be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
And that's what you want to do?
Yes, Your Honor.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You may lower your hand. I'm going to go over some rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again. You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court requiring that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
I do.
You understand you're gonna be giving up all those rights and you're not gonna be in a trial of any sort?
I do.
If you were on probation, parole, or bond when this offense occurred, which was on February 11th of 2025, you could be in violation of that probation, parole, or bond. And it looks like that's how you got your bond revoked in the other case, the 1007, correct?
Correct.
Were you on any other probation, paroles, or bonds?
No, ma'am. No.
And if you're not a U.S. citizen, you could have immigration consequences. You've had an opportunity to go over this with your attorney, correct?
Correct.
All right. To the charge of operating while intoxicated, how do you plead?
Guilty.
Has anyone promised you anything to get you to plead guilty other than what we placed on the record?
No.
Just let me know when they call your name, all right?
You in any way, shape, or form?
I beg your pardon?
Did anyone threaten you in any way, shape, or form?
No.
All right. Let's turn to the date of offense. On or about February 11th, 2025, were you at the vicinity of I-94 near Wired here in Ypsilanti Township?
Yes, I was.
You were operating a motor vehicle while you were present?
Yes, I did.
And while you were operating that motor vehicle, you were under the influence of alcohol, correct?
Correct.
All right, Ms. Muller, the BAC, please.
Judge, it was 0.225.
Defense stipulates to that result, Your Honor.
All right, I find that there's a factual basis for the plea. It has been willingly and knowingly made. Are you satisfied?
Yes, Judge.
Defense is satisfied as well, Your Honor. Thank you.
Sentencing in this case will be on April 21st, 2025 at 10 a.m. There's nothing else. Bond will continue.
Your Honor, I would like to address bond if possible.
Go ahead.
Your Honor, Mr. Hyman recognizes that this was a bond violation on his original case. He does deny the allegations of the original case he was on bond for, which is why we're setting it for final settlement. But regardless, he 100% accepts responsibility and understands that he was on bond and he did commit a bond violation. However, I just would like to draw attention to the fact that prior to these two charges, I don't, and Ms. Woods, correct me if I'm wrong, but I don't see anything on his record since 2008. So he has done a very good job up until now of not being in any kind of trouble. He works full time. He lives with his father. He's been very level-headed the whole time that I've been working with him since this case came to me from exams. I really believe he will comply from this point forward. He's happy to do whatever the court finds necessary to do so, whether that be GPS home confinement tether, scram tether. And I also think in this case, he already has 35 days credit. I would hate for him to get to the point of sentencing and have maxed out, because I think that what would be more beneficial for him is to figure out what was going on at the time of these charges, help him get maybe some resources that he needs. I know I've already explained to him the assessment process to reach out to probation. He's going to give me a call. If he were to be let out, he's going to give me a call as soon as he does, and we're going to walk through getting him assessed and getting him really set up for that sentencing date and a possible probation sentence. So at this point, I think that would do him and everyone else more good than having him max out possibly his sentence there in the Washtenaw County Jail.
Response, Ms. Woods.
Yes, Judge, I believe the reason why Simpson did what he did was the facts of the case are very, very serious with this DV case, Judge. And there was a third witness, neighbor, who is totally impartial and witnessed the whole thing, where the witness saw the defendant shoving the victim to the ground, saw him hold her down on the ground and put one arm around her neck and squeeze her throat, and then heard the defendant tell the victim, "I got something for you." Then the defendant went into his home and got a black AR type rifle and cocked the firearm at the victim, that's when the witness then ran inside her home because she was afraid that she would also get shot if anything were to happen. So the facts of this DV case are very, very serious, Judge, and I think that's probably why Judge Simpson did what he did in this case. So I just wanted to make the court aware of what the allegations were, and there is a witness, an impartial witness, who saw the entire incident.
Then why are we here? Why are we in misdemeanor court and not in felony court where this started as an FA if we have an independent witness? I don't understand.
Well, Judge, I didn't handle the preliminary exam. I'm assuming that the victim didn't show, but I don't know that. Let me
Well,
look at the.
maybe, and it appears that the independent witness didn't show either, because if she did, you'd be able to proceed on a felony.
Well, I mean, I don't know why they didn't show up to the exam, Judge. All I'm doing is telling you what the report says and why the judge probably made the decision he did.
Anything else from you, Ms. Muller?
Your Honor, I think I would just follow your argument there, and the time for that argument was at exam where he could have been held. That felony charge has been dismissed. Now we are left with a misdemeanor domestic violence, which again, Mr. Hyman denies, and that's why we are setting it. I think the bond was denied because of the violation. And again, my argument is that I think at this point, he's better served by getting out and getting resources rather than getting close to reaching his max time on this case.
I mean, to be devil's advocate here, yeah, I mean, I have concerns given that they apparently didn't have witnesses, and that's why we're here on a misdemeanor. But the allegations are still what the allegations are. Someone with the AR pointing it at people is very dangerous. And then on top of that danger, he goes while he's on bond, and he not only was he drinking, which I really don't understand why we're here on any of these, to be honest. Not only was he drinking, but then he's resisting and obstructing the police officer, which I'm not even sure why.
Can I speak?
No,
Just a minute,
No.
Mr.
I'm just now looking to make sure that on remand, it was a remand where count one was dismissed as opposed to reduced to an attempt. Yeah, count one was completely dismissed. So what is it you need to speak with your client again before I make my decision, because I have
Yes.
concerns.
Mr. Hyman, would you like to talk to me in a breakout room?
Yes, please.
Thank you, Your Honor.
The court will recall the matters of the state of Michigan versus Hyman. It was 25 FB 1036.
Ozell Hyman.
I thought I had already put my Tiffany Woods for the people.
Allison Muller here on behalf of Mr. Hyman. Your Honor, thank you for allowing us to speak. I just do have a couple additional arguments as far as bond concern, if that's okay.
You may.
Your Honor, Mr. Hyman just wanted to indicate to the court, and this seems correct upon my review of the police report, that no weapon was ever found anywhere in the home. I believe they searched Mr. Hyman's vehicle as well. There was no gun, as far as I can tell, ever located. Mr. Hyman also, according to him, indicated that the independent witness is a friend of the complaining witness in this matter. I believe they broke up a week prior to this. Again, the complaining witness and this independent witness did not show up at the time of exam, which is not definitively saying, but some indication of them not wanting to pursue this charge or the story that they indicated at that time. There's also pictures of the complaining witness that show, at least don't show any clear visible injury. Mr. Hyman did have a cash bond on this matter, which he was able to post. I understand there was the bond violation, but we would just ask that the sentence of that bond violation be the time that he's served. And Your Honor, I did want to say as well that in my review of the other charge involving the RNO, and I understand that's been dismissed and maybe not the primary concern of the court, but it was hard even in reviewing the police report to understand for me the basis of the R note, which I believe is why it was correctly dismissed.
I see. All right, thank you. That is useful. So his bond in this new OWI case, it looks like it's $100 with testing. Is that correct?
That's correct, Your Honor. I believe.
Do you have a place to be tethered to?
He does, Your Honor. You live in Inkster with your father, Mr. Hyman, is that correct?
Where did this happen? At her home?
Yes. Yes, at her home in Ypsilanti.
Okay.
412 is the address, Judge, where the DV happened.
Does he have any reason to be in Washtenaw County?
No, Your Honor.
I'm gonna do a GPS tether with an exclusion zone in Washtenaw County. Third, when that happens, you can't even come through the county on the highways and byways, so you can't be in the county, period. You understand that, sir?
Yes, Your Honor.
You're on an ETG test 3 times per month, sir. You need to find a place that is close to your residence and outside of Washtenaw County to test, okay?
Yes, Your Honor.
And they need to submit those to Washtenaw County. Failing to submit those or coming into Washtenaw County is a violation of your bond, for which you'll come back to jail and you'll sit until you get your other case resolved. Do you understand that, sir?
Yes, Your Honor.
All right, well, you got a number of court dates. You got one on April 21st at 10 o'clock, and you got another one on April 25th. So that week, I'll see you twice.
Yes, Your Honor.
Bond is continued on the 1036 case, which the testing is the same. 3 times per month testing. Any questions about that, sir?
No, Your Honor.
When will I see you next?
April 17th? My memory is bad. I'm sorry.
April 1st, sir.
April 21st.
On
Yes.
Zoom.
On Zoom.
If you don't show up here, you're gonna get a bench warrant.
Yeah.
And if you get another bench warrant, you're just gonna be sitting. So I certainly hope that you take this seriously.
Absolutely, Your Honor.
No, he has that time he has $100. He can post his $100 because I'm continuing it.
Mr. Hyman, can you post that $100?
I can. Now, as far as the DV goes, does that go for both of them?
That's the April 25th date at 11, okay?
Okay, so if I post mine, I
like-
can.
The bond that you posted is reinstated.
You said it was 50,000, Mr. Hyman.
50,000 cash
Yes.
or surety.
Okay. Thank you, Your Honor.
State of Michigan versus Liza Muckler, case number 23-00547.
Tiffany Woods for the people.
Allison Muller here on behalf of Liza Muckler. Ms. Muckler, could you state your name?
Liza Muckler.
Thank you. Good morning, Ms. Muckler. How are you doing?
I'm doing well. Thank you, Your Honor.
So does that mean you're better, or are you just saying you're doing well?
Being polite, I'm not doing better in terms of physical health. But
Okay. I'm sorry to hear that. You're still in your counseling?
yes,
Is that helping you at all?
oh, I love her. Yes, it's been wonderful.
Good. Well, I hear that you continue to do that and things are going well. I just want to make sure you're learning something while you're there. You keep in contact like you're supposed to. I'm really sorry to hear about your health. All right, you're making small payments on your fines and costs, so you're getting close to being done with us here. I'm gonna put your review in front of Miss Johnson, so you don't have to see me anymore after today.
Thank you so much.
You know, Ms. Muckler, I think you might be the person who has shown me the most amount of relief when you don't have to see me again.
Oh, I'm so sorry. I didn't mean it like that. I just get so terrified every time I come in. I didn't mean any disrespect towards you.
That's okay. I didn't take it as disrespect. It was not taken as disrespect. It was honest. It was real, and I appreciate the genuineness of that. And I'm glad that you and I started off very rocky, but you've shown me that you can do what you're supposed to do. I have been paying attention. I did not forget, and I appreciate all the work you're putting in. And I hope that it changes the way you interface with people in the future, and that it really does help you. That's what the goal is, just so you know. Okay.
I've learned so much and I really appreciate you and thank you so much.
My fear was that you were going to continue to go backwards if you didn't get this help now. And I believe you've learned, and I believe that you'll be a different person in the future. So you will see Ms. Johnson on June 16th of 2025. And once you complete your classes, if you could do a non-reporting if she sees fit to do that, so you don't have to keep reporting to us, but just keep working the program and take care of yourself, okay?
Thank you so much, Your Honor.
June 16th, 2025 at 9 a.m. with Ms. Johnson. Take care of yourself, ma'am.
Thank you. You as well.
All right, thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is a conference. It's an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in front. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so
I'm sitting up here, I'm the one that needs a drink.